All right, let's dive right in. Today, we're talking about something that's, well, absolutely critical for every single one of us in Canada. It's this constant tug of war between the power police have to do their job and our fundamental rights as people.
And let's start with a question that gets right to the heart of it. Your phone. I mean, think about it. Your entire life is on that little device, right? Your private messages, your photos, where you've been. So can a police officer just demand to look through it? You know, if you watch a lot of TV cop shows, you might think the answer is a quick and dramatic yes. But in the real world, here in Canada, the answer is way, way more complicated. And it all starts with our country's highest law, the Canadian Charter of Rights and Freedoms.
At its very core, this whole topic is a massive balancing act. On one side, you've got law enforcement, and they need the ability to search for evidence to solve crimes. But on the other side, the Constitution guarantees you a right to privacy. And pretty much the entire legal system here is built on finding that exact line between the two.
This right here, this is the bedrock, Section 8 of the Charter. And notice the key word, unreasonable. It doesn't say police can never search you or your property, it says they can't do it unreasonably. So the million-dollar question becomes, what makes a search reasonable?
Well, the starting point in Canada, the default answer, is that for a search to be reasonable, police need to get permission first. And that permission comes from a judge in the form of a search warrant. Think of it like a legal permission slip. It's not just a piece of paper, it's a massive check on state power, making sure the police have actual legitimate reasons, what the law calls reasonable grounds, before they can invade your privacy.
But here's the catch. Section 8 only kicks in to protect you when you have a reasonable expectation of privacy. So, what does that actually mean? It sounds kind of vague, right? Well, the courts have spent decades trying to pin it down.
So, let's try to make this real with a few actual cases. Picture this. You rent a locker at a bus station for a day. You put your bag inside, you lock it up, and you've got the only key. Is the stuff inside protected from a warrantless police search?
The Supreme Court of Canada looked at a case just like this, R.V. Buhai, and their answer was a clear yes. Because you rented that space and you had exclusive control over it with a key, you have a reasonable expectation of privacy. Police would need a warrant. Okay, how about this one? You put your garbage bags out on the curb for pickup. Now, it's your trash from your house, but you've put it out in a public space. Do you still have a right to privacy and what's inside those bags? In the case of R.V. Patrick, the court said no. The moment you put your trash out on the curb, where literally anyone could walk by and access it, you've legally abandoned your privacy interest in it. So police can go through it without a warrant. All right, let's get modern. You send a private text message to a friend. That message now lives on their phone, not yours. Do you still have any right to privacy over that conversation you started?
This one might surprise you, but the answer from the Supreme Court was yes. In a huge decision called R.V. Maraca, the court said that Section 8 protects the conversation itself, not just the physical phone it's on. As the person who sent the message, you still have a reasonable expectation that your private conversation will stay private.
So you can see how this gets complicated fast. How do courts actually decide these things? Well, they have a formal four-part test. They ask, what exactly is being searched? Do you have a direct connection to it? Did you personally believe it was private? And finally, the big one. Would a reasonable person in our society agree that your expectation of privacy was legitimate?
Now, we've been talking a lot about how a warrant is the gold standard for a reasonable search. But, like any rule, there are some pretty important exceptions. The law recognizes that there are situations where it's just not practical for police to go get one.
And here are the big ones. First, if you're being lawfully arrested, police can search you. This is for their safety and to make sure you don't destroy any evidence. Then there are emergencies, what the law calls exigent circumstances, like if someone is in immediate danger or evidence is about to be flushed down a toilet. And of course, they can search if you give them clear, voluntary consent. Finally, there's a limited pat-down for weapons during a brief stop, but only if they have a real safety concern.
And that point about consent, this is absolutely crucial. For your consent to be legally valid, it has to be completely voluntary and informed. If an officer asks to search your car or your backpack without a warrant, you have the right to say no.
And your consent, or anyone else's, has limits. In a case called R.V. Reeves, the court made it super clear that another person can't give away your constitutional rights. So your roommate can let the police look around the shared living room, sure, but they absolutely cannot give them permission to start digging through the files on your personal computer.
I think the most important thing to get here is that this line between police power and your privacy, it's not set in stone. It's a moving target. As technology completely reshapes what privacy even means, the law is in a constant race to keep up.
I mean, just look at this progression. Back in 2004, the court said using a thermal camera to scan a house from the outside wasn't really a search. They saw it as just external heat patterns. Fast forward to 2017 with the Marika text message case, and they're protecting the actual content of digital chatter. And then just recently in RV Bikevets, the court decided that even your IP address is protected information because it can reveal so much about you. Police now need a judge's permission to get it from your internet provider. The line is constantly moving.
So through all of these cases, from bus station lockers to garbage bags to text messages, all the way to IP addresses, there's one central idea, one core principle that the courts keep coming back to again and again.
And it's this. Your right to privacy isn't absolute. It can be limited. But it is fundamental to living in a free and democratic society. And so the job of the justice system is to constantly reevaluate and redraw that line, trying to respect both our individual liberty and the very real needs of law enforcement.
Which, of course, leaves us with the final and most critical question of all. As our cars, our homes, our smartwatches, and even our own biometric data become more and more connected, where will that line between security and privacy be drawn next?